Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. It's common practice in commercial contracts for the terms to state that when one party is in default, the innocent party must notify the defaulting party of a breach and allow typically a period of 30 days to rectify the breach before the innocent party is entitled to terminate. However, two recent cases, C&S Associates v Enterprise Insurance and Vinegary International v Richmond Mercantile, have flagged that if a defaulting party is in repudiatory breach of the contract, then the innocent party will have a common law right to terminate without notice, even where the contract requires a 30-day remedy period, unless the contract specifically makes the common law right subject to the same remedy period. A repudiatory breach of contract is where one party refuses to perform an obligation that goes to the root or essence of the contract, so it will only cover the major issues. Nevertheless, if a party wishes to avoid the risk of unintended termination rights, it is important that the contract is drafted to limit or exclude such rights. The Enterprise Act received royal assent on the 4th of May and will be implemented mostly by regulations that are expected to be enforced by October 2016. The Act has some far-reaching changes, including the creation of the Small Business Commissioner to support small businesses that have challenges with larger businesses, principally payment terms. A small business is defined as an enterprise with less than 50 employees. The creation of a statutory definition of apprenticeships and the setting of apprenticeship targets in the public sector in England. Minor changes to Sunday working. The proposed fundamental changes to extend Sunday opening hours were dropped, and a cap on public sector termination payments. We wait to see how effective the Small Business Commissioner will be in practice, but with most small businesses fearful of upsetting their large company customers, we suspect that few will turn to it for help. The recent case of Globe Motors Inc. and TRW Lucas Verity Electric Steering Limited concerned an exclusive supply agreement whereby Globe agreed to sell TRW certain automotive parts together with the engineering changes to those products. TRW, however, subsequently awarded the Gen 2 business to a competitor of Globe. Globe issued a claim for breach of agreement, claiming that as it would and could have produced the Gen 2 products, they were covered by the exclusive supply agreement. The Court of Appeal found in TRW's favour there were no words in the contract that expressly stated that the goods that would or could have been produced by Globe were caught by this contract. This reasoning is consistent with a spate of recent cases where the courts have taken a literal view of the words and have refused to interpret a contract to find the most likely intention of the parties, even where this has had unreasonable consequences. In this case, the court also took the opportunity to comment on the anti-variation clause that had been included in the contract. This clause, which is common practice in many contracts, stated that contract could not be varied orally or by conduct. There is differing authority on this point, but the court concluded that it is possible to vary a contract orally or by conduct, even where there is an anti-variation clause. In summary, contracts should take their literal meaning, except in relation to anti-variation clauses. Our guidance here is that anti-variation clauses should still be included, but should be very specific about how a variation can be made and who is authorised to agree a variation. This should be coupled with contract training to make relevant staff aware of the risk of inadvertent changes to contract terms. We have reported previously on the government's clampdown on nuisance calls. In May, the Privacy and Electronic Communications EC Directive regulations of 2003 were amended to obligate all direct marketing agencies to display their number on the phone of the person being called. Whilst this news is likely to be welcomed by most people, it will be important for any businesses that use telemarketing agencies to check they comply with these new requirements. The political lobby group Better for the Country has been fined £50,000 for sending thousands of texts in breach of data protection laws. Better for the Country obtained the list from a third-party supplier. However, it transpired that the individuals had not been given a clear explanation that they may receive promotional political messages. This is another case where an organisation suffered due to not checking the detail of the list that it had purchased. It is common practice for employers to put many of the details of the employment relationship into policies rather than being an integral part of the contract, to allow for variation without the consent of employees. The recent Court of Appeal decision in the case of Department of Transport v Sparks, however, has shed doubt on whether employers can claim something is not a contractual term simply because it is in a policy document rather than the employment contract. In this case, both the High Court and Court of Appeal had little hesitation in finding that the policy in question, an absence management procedure, was a contractual term and therefore could not be changed by the employer unilaterally. This was an unfortunate test case for employers, as the Department of Transport's policy documents had confusing references about what was and what was not a contractual term. It therefore seemed inevitable that this would be the decision. Employers need to be cautious about making changes to employment practices without proper consultation. In order to minimise the risk of a policy being considered to be contractual, we recommend it is clearly marked as being non-contractual. There is an express right to unilaterally vary. Words such as will and must are replaced with words like may. It includes a procedure that will be used for amending the policy. We have previously reported on numerous cases concerning what should be included in holiday pay calculations. These cases arise from concerns that if the average regular pay is not included in holiday pay calculations, people will be discouraged from taking holiday. The most recent Employment Appeal Tribunal case of White and others v Dudley Metropolitan Borough Council ruled that regular voluntary overtime must be included in the statutory holiday pay calculation. This case unfortunately has left the term regularly ambiguous. The Employment Tribunal stated the question to ask was whether the overtime had been undertaken with sufficient regularity to become part of the worker's normal work and therefore the worker's normal pay. If so, it should be included. The barrister representing the claimants in this case suggested that 1 day per quarter should be sufficient to be classified as regular, but working voluntary overtime once or twice a year would not be sufficient. It should be noted that this is a first instance decision, so there may be appeals. A similar first instance decision has also been reached in the case of Whitehead and others, the EMH Housing Regeneration Limited, concerning standby and call-out allowances. The Locke v British Gas case, which held that commission payments should be included in holiday pay calculation, has now been listed for a Court of Appeal hearing on the 11th or 12th of July. The Trade Union Bill completed its rocky ride through Parliament and became the Trade Union Act 2016 on the 4th of May. The Act does not specify a commencement date. Whilst the Act has lost some of the more contentious parts following challenges in the House of Lords, it does still bring some significant changes. These include the requirement for a 50% turnout from all eligible voters to authorise industrial action. Industrial action in essential public services such as health, education, fire has a double threshold, demanding at least 40% of those entitled to vote to be in support of the action. But this does not include ancillary workers engaged in these essential services as had originally been planned. The balloting must have a clear summary of the matters at issue in the trade dispute, together with details of the proposed action to be included on the ballot paper. Ballot mandates will only be valid for 6 months, or where agreed with the employer, up to 9 months. And existing union members will no longer be compelled to opt in to paying the political levy of their unions. Instead, only new union members will be required to opt in. In the case of Hills v Nixon Inc., Mr Hills was employed as a regional sales manager and brought a claim for underpaid commission. He argued that Nixon had failed to reasonably exercise discretion by only allocating 48% of the available commission to the UK office. The High Court agreed with Hills and concluded that it was not lawful for the UK office to be awarded less than 2/3 of the commission. Nixon appealed and argued that its contract documents were clear that it retained the discretion to award commission as it deemed appropriate. The Court of Appeal was not persuaded by these arguments. They stated that because Hills had demonstrated that there were grounds for thinking that Nixon's decision was unreasonable, it was then for Nixon to counter this by showing its decision-making process was reasonable and rational. Nixon failed to do so. Now, this case illustrates the importance of employers maintaining appropriate records to identify their decision-making process about commission payments. An employment tribunal has ruled in the case of Wickers v Colchester Visionplus Limited that the company was guilty of discrimination arising from disability. This case concerned an employee that had told the employer she was suffering from depression, but after some periods of absence and making some mistakes, the director told her that everyone gets depressed sometimes, you just have to pull yourself together. Section 52 of the Copyright Designs and Patents Act of 1988 limits the term of copyright protection for industrially manufactured artistic works, that's works of more than 50 articles being produced, to 25 years. This is significantly less than other artistic works that have protection for the author's life plus 70 years. Following a European Union decision, it has been accepted that Section 52 will be repealed to create consistency in copyright protection. The government initially set a repeal date of April 2020 to allow time for businesses to adjust. However, following consultation, it has now been determined that Section 52 will be repealed from the 28th of July 2016. The depletion period for existing stock produced or acquired under a contract entered into before 28th of October 2015 will end on the 28th of January 2017. This is clearly good news for designers of products that have suffered from other manufacturers making copycat products. Sweet Group plc has been ordered to pay £2.25 million after pleading guilty to a Section 7 offence of the UK Bribery Act, failing to prevent bribery. In this case, Sweet Group's subsidiary secured a contract with the AAIC to manage the construction of a hotel in the United Arab Emirates. It also entered into a contract with a company owned by a director of AAIC, the North Property Management NPM. In the investigation, it became clear that NPM had not provided any services, and the contract, as summarised by the sentencing judge, was a vehicle to provide a bung. This case, together with the recent Standard Bank DPA and the Brand Rex case, demonstrate that the Bribery Act is finally starting to show its teeth. Thank you for joining us for this month's commercial bulletin. The website details of Radius Law and LexisNexis will be shown on your screen in a moment. Please feel free to contact me if you'd like more information on any of the topics covered, and if you've not already done so, you can get access to more content with Lexis PSL. Please don't hesitate to contact my colleagues at LexisNexis to request a free trial. Any other feedback on the bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.